I'd like to welcome everybody to NGO Monitor's webinar on the International Criminal Court's intensifying efforts to target Western democracies, in direct contrast to and in violation of the Rome Treaty, which established the International Criminal Court. I'm Gerald Steinberg, president of NGO Monitor, and I'll be your host for this webinar. I'm honored to welcome our participants, Colonel Richard Kemp and NGO Monitor's legal advisor, Ann Herzberg. Mr. Kemp is probably very familiar to many of you, based on his record as a British Army officer for 3 decades, including service as an infantry battalion commanding officer, his role in Afghanistan, and many other accomplishments. After retiring from active duty, he has contributed a very important and clear-headed voice on many of the human rights and international law issues of the 21st century, and holds important policy and advisory positions, including as a member of NGO Monitor's International Advisory Board. Ann Herzberg is a graduate of Oberlin College and Columbia University Law School, and has been a senior staff member of NGO Monitor for many years, representing our organization in the UN and authoring a number of important publications, including the pioneering NGO Monitor monograph on lawfare, in which she anticipated many of the issues we're discussing today. I want to thank you, both of you, for joining us, as well as everybody out in the audience. The topic of the International Criminal Court and its targeting of democracies is particularly acute. After a number of years of collecting materials, the prosecutor, Fatou Bensouda from Gambia, recently filed a brief with the pretrial chamber asserting jurisdiction and preparing to initiate a formal investigation of Israelis, and similarly is investigating war crimes allegations in Afghanistan, which would include American forces and could potentially involve British troops as well. Before we get into the specifics, I want to start by asking you to explain the threat posed by the International Criminal Court to democracies, to sovereignty, to independence, self-defense, particularly in terrorist and asymmetric warfare situations. How would you rate, we'll start with you, Colonel Kemp, how would you rate the major concerns in this area? Okay, go ahead. There you go.
Can you hear me?
Now we can hear you.
Yeah, okay. We're as I say, greetings from Southern England. We normally have lousy weather here, but we're doing pretty good. I'd like also to say what a pleasure it is to take part in this event hosted by NGO Monitor. I've been associated with NGO Monitor for a long time, and I can say nothing but the greatest praise for the extraordinarily good work you do supporting freedom and liberty. And keeping an eye on some of these so-called NGOs who would like it to be otherwise. In answer to your question, Gerald, I think the International Criminal Court is an extremely important organization. Of course, it follows on from the Nuremberg trials, where you remembered it certainly in Israel only yesterday. Some of the worst war crimes committed by the Germans were against the Jews in the Holocaust and against other people in the Holocaust. And that trial at Nuremberg was an extremely important part of the process in dealing with the Third Reich after it fell. And of course, the International Criminal Court follows on from that. And there are injustices, there are holocausts of a sort, there are genocides, there are war crimes, there are crimes against humanity going on around the world. And it is necessary to have a body to deal with that, and that body, of course, is the International Criminal Court. But there was always a danger when this court was first created back in 2002. There was always a danger that it was going to be abused for political purposes, in particular to bash Western liberal democracies. And unfortunately, that's what it's already been doing. Certainly when Britain decided to join the ICC back in 2002, I was one of many people who warned against that, who made it clear I supported the ICC, but I did not support Britain from joining it because, for really 2 principal reasons. One, because Britain has a very effective, long-established, 1,000-year-old legal system, which is always used to deal with when military people or other people here commit crimes or are accused of committing crimes. That legal system deals with it. We don't need external assistance from anything like the ICC. And that goes pretty much for every Western democracy. It's needed in countries where there is not that, that rule of law, that willingness or even ability to try people who have committed war crimes. And also the second factor that I was aware of when I was certainly warning against this policy decision was that there are people who want to use these kind of bodies against us, as the UN Human Rights Council, for example, is always being used against countries like Israel and Western countries. And lo and behold, now we have, and it's already been mentioned, we have 3 countries outside, 3 Western democracies that are in the crosshairs of the ICC. Israel for alleged crimes in Gaza and in Judea and Samaria. The United States for alleged crimes in Afghanistan, and Britain for alleged crimes in Iraq. Of course, the 3 normal suspects are the focus of these people who want to actually undermine our democracies, undermine our way of life. And they want to stop us from doing what we need to do to fight the kind of asymmetrical warfare we face today. So, in my view, it's those things, those are the biggest threats, the reason that we face a threat from the ICC. I think the final thing I'd make before letting Harold is that why are other countries not in the crosshairs of the ICC? Why is France not? Why is Germany? Why are these other countries not? Well, they would be, except that it's our country, it's Britain, it's America, it's Israel, really, that is in the absolute forefront of fighting these wars. We are the 3 countries that, more than any other countries, and I don't in any way do anything to sort of undermine or underplay the role that France has been playing in various places, particularly in Africa, but also Germany to an extent as well, and other countries, other European countries. But it is our 3 countries that are the main forces, the main nations that are fighting the war that faces us all, the global struggle against international jihad, which faces us all and against which the ICC is ranged against us.
Anne, would you like to go further with this?
Yeah, definitely.
Background?
Yeah, thanks for having me. I definitely want to second what Richard said. I don't believe that the court was essentially set up to go after mass atrocity crimes for places that did not have functioning judicial systems, not to micromanage targeting decisions in asymmetric warfare, which is unfortunately the direction they're taking for many reasons. But I think also it's important to point out several flaws in the court that is sort of driving the problems that we're seeing. And I'll just lay out a few of those. Number one, the uncertain state of the law. So the judges of the court are essentially making it up as they go along. And there's no political or democratic checks. You know, when you have a Supreme Court in a country, when you have a judicial system, there are checks on the decisions made by those courts. There's a legislature. If they don't like how the courts are interpreting the law, they can enact new laws. We don't see that with the ICC. Another big problem, which I've never gotten a satisfactory answer for, is the retroactive application of the law. So the court can try people for activities that took place before the country at issue was a member of the court. And that's a violation of a fundamental principle of the law, which I find highly problematic. And other major issues are lack of expertise. As far as I know, they do not have a military expert at the court. That may have changed, but last I checked, they did not have that. And I don't see how they can be ruling on things like war crimes without any type of military expertise. There was an independent review of the court regarding the Kenya situation that came out in November 2019. And in that review, they found that the staff had inadequate expertise as well. So they did not have enough expertise in complex criminal investigations. And we're talking here about a criminal court. This is not just some UN panel. This is a body that has real consequences depending on the outcomes. People go to jail, people get indicted, people get arrested. So to have people who don't have expertise in criminal trials is highly problematic. The judges do not necessarily meet the standards of judges that one would expect. Evidence, reliance on hearsay evidence. Again, a lot of the failures with the court are things that, you know, a lot of the NGOs that prop up the court, they would never accept the situation in domestic courts. If you look at their websites, they rail against these things in the United States, in Israel, in the UK, and yet these practices are okay for the ICC. I don't understand that. Politically driven prosecutions. The court has had a lot of criticism for going after African countries. I don't think that criticism is warranted, because if you look at the atrocities that were going on in Africa, they were the types of things that would be covered by the ICC. But because the prosecutor needed to get other countries that weren't from Africa, she started going after Western countries, and also in particular countries that are not members of the court. And so I think that's also highly problematic. And then finally, I'll just say the lack of transparency. There's not a lot of transparency on the funding, on partnerships, the role of NGOs at the court, which is highly influential. There's no freedom of information mechanisms, and really little oversight on what goes on there. So I'll leave it at there for now.
Thank you. I think those are both very important introductions to this. There's a lot more that we can look at. When Richard Kemp was talking about the origins based on the precedent of the Nuremberg trials, and more specifically, I remember when there was a lot of talk back in the late 1990s about dictators who had done really very vicious things and were exempt. They were just not going to be held accountable in their own country. Colonel Pinochet in General Pinochet in Chile, and Milosevic in Serbia. Those were the precedents, also in places like Rwanda and Congo and elsewhere. Those were the precedents that drove the International Criminal Court. And the question is, why has it got so far off of those their original mandate? And I want to be very specific, since this webinar was set up and sponsored by NGO Monitor. I want to go to the role of the NGO network, the non-governmental organizations. I remember back in the late 90s and early 2000, 2001, when we were watching the Rome Treaty negotiations and discussing the additional elements that were added that indicated that this was a direction that was going to be pushed, dealing with, trying to target Israel, dealing with settlements, dealing with the United States, trying to target Americans and Brits and others. And the NGOs were very involved even back in those days. Human Rights Watch and International were pushing very hard for the establishment of this framework. Of course, from the research we've been doing, from the conversations we've had with both of you, seeing the political agendas, the ideological agendas of the NGOs. So what I'd like to do now is ask, maybe we'll start with Anne on this one, which NGOs are most active in these specific cases now of pushing the International Criminal Court into targeting the Western democracies, including, of course, Israel, but also the United States, the UK. Those, I think, are the NGOs, from what we've seen, play a very significant role. They're very powerful actors in these types of frameworks.
Yeah, sure. Yeah, so NGOs from the very outset, you know, even the negotiations at the Rome Statute played a central role. They garnered support for the court. They were very active in pushing for an independent prosecutor role. Initially, it was just referrals to the court were only going to be available via the Security Council. And they pushed for this independent prosecutor role so that she could initiate cases on her own. So that's been a significant source of problems. Again, this expert review that I spoke about mentioned that a lot of the prosecutions seem target-based rather than evidence-based. So they're identifying people they want to go after without following the evidence. And I think that directly reflects the role of NGOs, because it's reflecting their political agendas. Who are the people they want to go after? The NGOs most involved, I would say, are Human Rights Watch. And this has been, you know, since the beginning of the court. The Coalition for the ICC, Soros's Open Society Justice Initiative. So they've been the primary actors in terms of pushing the court, promoting the court. They're involved in a lot of meetings at the court in terms of influencing process there. And then later on, when we get into the Israel case in particular, there were a host of Palestinian and even a couple of Israeli NGOs that were involved.
Thanks. I'll ask the same question of Richard Kemp. I think I remember, you actually were one of the people who testified, was invited to testify before the Goldstone Commission way back, I think 11 years ago, 2009. And as I recall, they completely ignored your testimony. You were anathema to the NGOs that were promoting this issue that international law forbids all sorts of responses, military responses, security responses to terrorism. This was in the respect to the Gaza war. Now you're having to deal with this issue in terms of British forces in Afghanistan. I don't know if the case is on Iraq specifically before the ICC, but of course there have been campaigns in the UK led by NGOs and individuals who saw themselves as the carriers of the torch of morality, but were actually trying to prevent the defense against terrorism. Can you talk a little bit about your own experience in dealing with these issues?
Yeah, I mean, I've been involved with the UN Human Rights Council in trying to bring a more objective picture to them over all three of the recent Gaza conflicts that Israel's been involved in, and indeed not just the three kind of time-specific ones, but also the one that's been going on in recent months, last 18 months, 2 years along the Gaza border. So effectively 4 separate Gaza conflicts. And to pick up on a point that Anne made earlier on about the ICC and their lack of military expertise, and it's true, they don't have any military experts in the ICC. And the same goes for you and Human Rights Council. I gave evidence to them, both in emergency sessions in Geneva and also in front of them during their inquiries and investigations of officers. And they had nobody who had the first idea about military operations. Now, how do you investigate human rights issues in a war if you don't have anyone that's ever fought in a war? At one point they had, I've forgotten his name now, but they had an Irish colonel who was the military advisor for Goldstone. And actually, you know, he represented an army that's never fought in a war. And they were dealing mainly with air operations in relation to the Gaza conflict. And the Irish state doesn't have an air force. It has a few helicopters that carry VIPs around and so on. But so they had the wrong person there. And subsequently, I tried my hardest to find a military expert that they actually had, and they didn't have one. So I think that says a hell of a lot about it. And you're right, they didn't take any notice of what I said. They listened. They listened politely. They asked me questions. In fact, the chairman of one of the 4 commissions I spoke in front of said she was extremely grateful to me for going there. And she admitted they didn't have a military expert, but didn't make any difference. They didn't really take it into account because they have their agenda. Their agenda is set. The mandate that each of these commissions has been given is not a fair and open mandate. It's a mandate specifically aimed at achieving what they want to achieve, which is to put Israel on the chopping block. And indeed, these commissions have been very keen, and the UN Human Rights Council have been very keen and desperate to get Israel into the position that it's in now in front of the International Criminal Court for a long, long time, and they've succeeded now pretty much. And my final point I'll make about those people who are behind these moves. In Britain, we have a number of organizations. Obviously, the usual suspect NGOs are involved in it, but then we have groups like things called Stop the War Coalition, which is a hard left-wing so-called peace movement, but actually the only wars it opposes are the wars that Britain's fighting. It doesn't oppose wars if other people are fighting them. And it has nothing much to say, for example, on President Assad's treatment of his people in Syria, but it does have a lot to say about Britain's efforts to try and combat global terrorism. And it's organizations like that and lawyers like Phil Shiner, who was a human rights lawyer who brought the initial case against Britain for its alleged war crimes in Iraq, accusations of mass murder, rape, torture, etc. And that was that investigation at the preliminary examination stage is still going on. Yet he, who was one of the main movers behind it, has been discredited. He's been struck off as a lawyer. He's been proved to be going against all best accepted legal practices and basically concocting evidence and paying people to come and give evidence. And so, you know, a lot of the foundation, a lot of basis for this has been undermined, yet still the International Criminal Court is proceeding, and they're proceeding in the full knowledge that, notwithstanding the shortcomings of the court that Anne mentioned earlier, but also the fact that we have an extremely well-developed legal system in the UK that has put people in prison for committing crimes in war zones in the past, and will do in the future if it's necessary to do it. We don't need to be told what to do by the ICC. And in many ways, I don't blame the ICC for it. You know, obviously they have their share of blame, but I blame the British government for allowing them to have any jurisdiction or influence over us all. The government, the British government, and also the US government and the Israeli government, as appropriate, should be the ones who are really pushing back against this and refusing to accept it. I'm very pleased to see that does apply in both Israel and the US, but the British government seems to be more inclined to allow this abuse to continue.
I think we're getting deeper and deeper into the complexities and the failures of the whole ICC process. I want to talk specifically now, or ask Anne to start on the Israeli case. What we saw just before, actually after many of us went into quarantine, the ICC continued to function, and the prosecutor then sent her briefing claiming jurisdiction to the what's called the pre-trial chamber, 3 judges that are supposed to rule on whether in fact the ICC has jurisdiction and can bring a case, they claim, against Israel and against the state of Palestine, whatever that may be. And the process of the briefing that she submitted was one that, from the analysis and from the amicus brief that NGO Monitor submitted with some other groups, I think the term shoddy was used in that it was just put together, slapped together, all sorts of bits and pieces, missing important parts of history. Can you talk a little more about that and your evaluation of that briefing or that document?
Sure. Before I do that, though, I think it's important to talk about the history of the Palestinians joining the court. I think it's very important to just briefly go over that. So in 2009, the Palestinians attempted to join the court. And the Rome Statute is very clear that the only entities that can join the court are states. But in 2009, the Palestinian Authority tried to join the court. And rather than just dismissing that filing outright, the prosecutor at the time, Luis Moreno Ocampo, launched a very improper PR effort that lasted for 3 years, that involved NGO meetings, op-eds in the paper, a forum at UCLA Law School, briefings, allowing people to file briefs to determine whether or not he should open an investigation relating to Israel. And in 2012, after this whole process, which was completely out of line for a prosecutor. I don't know any prosecutor that's really done something like that before. And also in the middle of this process, I should just add, Mahmoud Abbas wrote an op-ed in the New York Times in 2011, basically saying that the Palestinian Authority, Palestine should be accepted as a state such that they could internationalize the conflict and use bodies like the International Criminal Court to go after Israel. So this happens in 2011. Mahmoud Abbas lays out the Palestinian strategy quite clearly. But in 2012, the prosecutor decides, Palestinian Authority is not a state, and therefore he is not going to proceed. But what he did was lay out a roadmap for a way in which he thought the Palestinians could join the court. So later that year, the new prosecutor takes over, Fatah Bensouda from the Gambia. And she basically also goes on a PR effort, putting, again, op-eds in the paper, encouraging the Palestinians to join the court. The UN General Assembly does this cute little move, admitting the Palestinians as a non-member observer state. And then she claims that that's enough for the Palestinians to join the court. So in 2015, she has a whole process for how she launches investigations. It was sort of a pre-investigation. So that had been going on for many years. And then in December, she filed a brief with, or basically a request with the pretrial chamber, asking for them to confirm that she could go forward and open a full investigation against Israel. And in doing so, she made the claim that the territory of the state of Palestine, in her words, was Gaza, East Jerusalem, and the West Bank. And so she's seeking confirmation from the court that this is the territory and that she can open investigations of Israelis, even though Israel is not a member of the court, on potential crimes. So at that point, the court allowed people to file amicus briefs. They had to request permission, which we obtained. And we filed a brief with a host of partner groups. And our brief actually focused on 3 specific issues. Number 1, that Palestine does not constitute a state and therefore cannot join the court. Number 2, in her brief, she gave a whole history of the Arab-Israeli conflict that was completely one-sided. She omitted the context of terrorism, and she relied solely on UN documents in presenting her history, UN General Assembly resolutions, reports of biased UN entities, the Human Rights Council, and basically said that whatever they say in these UN General Assembly resolutions is what the court should follow. And then the third thing was that she completely misinterpreted the Oslo Accords. Under the basically, it's important to note that the court is based on consent. So only countries that agree to give their criminal jurisdiction to the court are allowed the court is allowed to take jurisdiction over those cases. And under the Oslo Accords, the Palestinians do not have any criminal jurisdiction over Israelis. And so there was no ability for them to delegate any jurisdiction to the court. And so these were 3 critical failings in her filing. So right now, and there were a whole host, there were probably 30 briefs that were filed. Very many very prominent figures, Ambassador Dennis Ross, Erwin Kotler, former Obama officials, the countries of Germany, Czech Republic, Uganda, Brazil, Hungary, I'm forgetting a couple, Canada, also made statements and filed briefs that the court does not have jurisdiction in this situation. So now she was supposed to file a response to all of these amicus briefs by March 30th, but because of the COVID, she's asked for an extension, which she was granted. And at the end of April, she's supposed to be handing in her response. So it'll be interesting to see how she responds to, I think if you look at the legal arguments, they're almost entirely against her. So it'll be interesting to see how she tries to address them.
Before we go on to the specifics of the Afghanistan case, we've got a lot of questions that have been asked. And I want to tell people who are out there that we will have some time for those questions towards the end. So I'm not ignoring them. We know they're out there. Hang in for a little bit longer. We'll do some of the other specifics, and then we'll go on to the questions and try to get some answers. The Israel case is pretty clear. I'll just add also that in all of these cases, and you go back to the Human Rights Council, as Richard talked about, and I know we've had you there as a speaker, and we've seen you speak on a number of different occasions. And it's always this artificial, we're going to investigate war crimes of Israelis, and we're going to investigate war crimes of the Palestinians. I think there were a few pages in the 500-page Goldstone report that mentioned briefly that wasn't one of the 36 cases. But I think it stands out, the fact that there's a fig leaf of saying we're going to do some even-handed investigation and a sort of a very minor bow to universality. But in fact, there's very, very clear targeting, and clearly it's not of any interest to the Palestinians, not the Hamas or the Fatah movement, whether they're investigated by the ICC or not. It's irrelevant to them. And for Israel, obviously, as a member of the international community, it's something that it's very much a form of demonization. I want to go on in sort of a similar vein to ask them about the case of Afghanistan and the British response. I'll just start with the American case, because I think Mike Pompeo, the Secretary of State, very clearly enunciated a one-sentence policy. He said, "This is truly breathtaking action by an unaccountable political institution masquerading as a legal body." And the US response was, as a first step, was to announce that officials from the ICC will not be getting visas. Today, there are not many planes coming in, whether from The Hague or anyplace else. But the fact is that that was a clear sign of saying, we don't consider what you're doing to be legitimate, either legally or in any other framework. And the British government is a signatory, unlike the US and Israel. The British government is a signatory to the Rome Treaty. They are members of the International Criminal Court. Is there discussion at a high level? Again, I guess I'll go to pre-Corona days, and then perhaps it'll come back after the Corona days, about leaving the court, about saying this is not what we signed up for, and other actions of protest against these kinds of activities. Now you got to unmute. Richard, you got to unmute.
I'm not muted, I don't think. Am I muted? Can you hear me?
We can hear you. Go ahead.
Okay, I'll go ahead. Yeah, in Britain there has been a great deal of discomfort and in some cases outrage among the public for the way in which the British government has allowed its service people to be hounded through the court over decades in relation to both Afghanistan and Iraq, and actually Northern Ireland as well, but that's a separate thing. I'll leave Northern Ireland aside because it is a little bit separate, although related. But certainly Northern Ireland and Iraq, we have seen, Afghanistan and Iraq, particularly Iraq, we've seen thousands and thousands of soldiers subjected to investigations, inquiries, legal process, criminal court cases over allegations of war crimes in Iraq and Afghanistan. And, you know, soldiers who volunteered to fight for their country, they were put in the most difficult positions, the most dangerous positions. They saw their friends killed or maimed alongside them. Have, in some cases, as I say, for over a decade, been hauled through these processes. Marriages have broken down. Some soldiers have been close to suicide and even attempted suicide over it. And we're talking about a very large number of people here. And what was the reason for it? The reason is because I alluded to it in the last time I spoke, the British government has been too weak to stand up to the people that are accusing its forces of kind of a mass criminal activity. It couldn't happen. It couldn't happen on the scale that's been alleged in the British Army unless it came from the very top, unless it was the Chief of the Defence Staff who was directing war crimes to be committed. And of course, that hasn't happened or wouldn't happen. And you know, instead of standing up for this, the British government has allowed it and accepted it. And why? Why is that? It's really for two principal reasons. One is to appease those people who are uncomfortable about the fact that we have been fighting jihadist enemies in Iraq and Afghanistan, and killing them in some cases and imprisoning them in other cases. And the government wants to be able to say, well, look, we had our own bad eggs as well here, and look what we've done to them. That's, again, it is a sign of the gravest weakness to throw that kind of abuse at soldiers who volunteer to fight. Of course, soldiers make mistakes. Of course, soldiers get things wrong. You get bad soldiers as well as good soldiers. But we have a perfectly legitimate system of dealing with it through the normal criminal process. But why has it become so widespread? It's become so widespread and such a big problem because the British government's running afraid of the International Criminal Court. The British government knows, because the ICC has got its crosshairs on Britain, for reasons we've already discussed, the government knows that if the ICC can find a reason to come after Britain on any of these things, it will do so. And therefore it needs to be seen to be squeaky clean, cleaner than clean. Because Britain is terrified of the possibility that its soldiers, its commanders could be dragged into The Hague. And that would be a political disaster for this country. So it is taking the only way that it knows out of it, which is to allow its soldiers to become victims of what is effectively a legal witch hunt and a politicized so-called law, which is political warfare in effect against them. And that, that is what we've seen. And the accusations they're not quite the same as have been made over Israel, but they amount to similar kind of things of deliberately targeting and killing innocent women and children, as Israel's been accused of carrying out rape and torture. And it's the same goes for the US. It's US forces, British forces in Afghanistan, and British only, I think, at the moment in Iraq. But one thing I'll pick up one point you made about how the Taliban, how Hamas really don't care whether they're targeted or whether they're accused of war crimes, makes no difference to them, whereas it does to the IDF. It's the same in Iraq and Afghanistan. The Taliban, the ICC, as UN do in their various different guises, they pay lip service to the horrors carried out by the Taliban. They say, we're going to investigate the Taliban, we're going to investigate the Mahdi army in Iraq, we're going to investigate these other jihadists, as well as the Western armies. And by doing that, they're making a moral parallel. They're effectively putting prescribed, brutal, vicious, violent terrorist organizations on exactly the same level as democratic states. And that's part of what they're trying to do, of course. They're trying to they're trying to show the world and trying to undermine our national institutions by putting them onto the same level as the enemies that we're fighting. Of course, it's completely different and completely wrong for these parallels to be drawn. Moral equivalence. It's one of the main objectives, I think, of those people who are pushing behind the International Criminal Court, the UN Human Rights Council, etc. As I think you said, that they couldn't care less. It's not in their interest. The only observation they give to the laws of armed conflict or any other law is the way in which they can use those laws to exploit our adherence to them, or Israel's adherence to them, or the United States' adherence to them.
If I were doing an academic webinar discussion, I would talk about post-colonialism and ideology and what's behind driving this anti-Western, anti-American, British, Israel, anti-democratic processes in all of these agendas, all these different, or these institutions, because the patterns are very similar. We see them coming up over and over again. In fact, the Goldstone, one of the main objectives, maybe the main objective of the Goldstone process, and I have to say that at least Richard Goldstone himself denounced it or pulled back from it a year later. It took a while, but in any case, the purpose was to set up the case. And in a certain sense, this was 2009, the case, they were going to go to the Security Council, and they were going to, if Israel and Palestinians, Hamas, didn't comply, then there would be a recommendation of the International Criminal Court. The fact that here we are 11 years later says that all the efforts to try to use the Human Rights Council were slowed down to use it to get, but here we are, we're still at the same point, or on the brink of the same point. So I'm not going to do the post-colonial, go into the details of that now. Maybe we'll do another more focused academic seminar on the origins, the history. And it's interesting though that people who have that ideology do congregate around international institutions because they can manipulate them. They have the power, and NGOs, the two go together. Non-governmental organizations. You don't have to get elected. There's no democratic process. There's no legitimacy. There are no checks and balances. And these things are I think, common to both of these processes. And it leads to the power. It's soft, we call it sometimes soft power also. That we'll put that together with the other academic issues. I'm going to go to one of the questions, or there's a set of questions, actually, a number of questions, and I will apologize. We've got about 120 people now watching us. It's a good group. And a number of the questions focused around an issue that's not really on our agenda, but I think so many people asked about it, I'm going to raise it. The question of China and Iran as violating international norms of very consistent, very visible violators of basic human rights norms around in their own countries and outside, both, and also their use of military force to expand their power. And so the questions that were asked, again, by a number of people come down to, why aren't international institutions more focused? Why aren't NGOs more focused on Iran and China? And of course, we know the case of the World Health Organization. You don't bite the hand that feeds you. That's certainly one of the reasons that China and Iran tend to be exempted from this process. But also, they're not part of the Western world. So I've already answered at least part of that question. But I'll throw it back to you, and I think that deserves a little more discussion.
Yeah, I would just say, I mean, the court, even though, well, in the case of China and Iran, they're not members of the court. So that makes it a little bit difficult. If they were, there's certainly room
Israel, but okay.
Right. Well, so they could go after them under crimes against humanity, even if, I mean, in the case of Iran, they are involved in armed conflict that comes up in various countries. Where potentially, you know, their involvement could fall within the jurisdiction of the ICC, and certainly crimes against humanity within their own countries, against their own peoples. Even though it's not an armed conflict, they certainly could, the court could go after those countries were they members of the court. But certainly no one's really looking at that in any, as far as I'm aware, in any significant degree. And I'm sure though, if there was a will, they would find a way to do it. But they're not. So
I'll just add that when we monitor what the global NGO human rights superpowers, Human Rights Watch, Amnesty, FIDH in France, others, what their agendas are, what they're pushing, yeah, they do criticize China and Iran every once in a while. But as you said, there are no campaigns. There's no strong effort in any of these international institutions to hold these primary violators of human rights accountable. Richard, do you want to add anything to that?
One point I should have made when I was speaking just previously in answer to your question about the Afghanistan and Iraq cases, and that is that you know, under a great deal of pressure from the British public and from the media to an extent, and from former soldiers, the British government is now in the process of enacting legislation to try and prevent this from happening again. I won't bore you with the details of that, but it's in its early stages of development. And of course, like most things, it's on hold because of what President Trump would call the Chinese virus. But I do believe strongly, and I'm happy to address this further later on if you want to talk about how we deal with the ICC later, perhaps. But I do believe that the only way Britain really can avoid being continually dragged into this by withdrawing from the Rome Statute and completely abandoning its jurisdiction from the ICC. But in answer to your question, again, very briefly, you answered it yourself. The reason why the ICC is not focused really on China and Iran, not because China and Iran aren't members of the ICC, America's not a member of the ICC, Israel, as you said, isn't either. It's because they're not Western countries. It is this post-colonial guilt. It's the determination to punish us for the alleged crimes of our forebears in the British Empire, the French Empire, other empires. That's what it's all about. And of course, Israel, to my knowledge, never did have an empire, but Israel is part of the American empire, so it has to be punished for that reason as well as numerous others. And of course, part of a British imperial project. You know, that is the reason, but there are other reasons as well, and you know, we know the closeness, as you touched on it, the closeness of China and the WHO, and WHO is not China is not by any means the major funder of the WHO, but nevertheless they're extremely close. Why? There's a lot of stuff going under the surface on this, and the same applies between the ICC and China in particular, not maybe Iran to an extent as well. But China has developed over the last 70 years numerous ways of controlling people in ways that are not obvious, but do cause different international bodies, individuals, to be very cautious in what they do about China. And I think, you know, I think we could probably, I have no evidence for this, I think we could probably expect there's every reason why China has a great deal of influence on a, shall we say, under the counter basis in relation to the ICC and other parts of the UN.
I'm going to ask you to go into a little more detail on the, you said, how do we deal with the ICC? You have more to say about that, and maybe a little bit about the legislation. I should say, by the way, the questions on on China in particular, Johnny Gould asked that question, so I think you appeared on his program as well recently. So I'm going to put two questions at once. One is I'd ask you to talk a little bit more about what do we do with the ICC problem in general and what's going on in the UK. And Anne, maybe I'll ask you, we have a question. We assume that everybody knows how the ICC works, but of course that's not the case. It's pretty arcane. So could you spend a few minutes talking about the structure of the ICC, the processes that are involved, how many judges, how are they chosen, what size panels, how does that work?
Okay, that could be a pretty lengthy answer, so I'll just give a brief.
We're down to the last 10 minutes.
Exactly. So I'll just give a very brief overview. So there is the Rome Statute that governs how the court works. The court has jurisdiction over 4 different types of crimes: aggression, genocide, crimes against humanity, and war crimes. And within those crimes, they specify particular actions that may fall under those crimes. There is an office of the prosecutor, which does, investigates, prepares indictments, and then tries the cases. There's a pretrial chamber. I don't want to get into too much detail, but depending on how a state has joined the court, the prosecutor may or may not have to ask the pretrial chamber for authorization if she wants to go open a full investigation. So typically she starts looking at a situation to determine if she wants to open an investigation. She then opens the investigation, sometimes with, sometimes without court approval. And then in the course of that investigation, we'll draw up indictments. And then, then it's a whole court process.
And can you just talk a little bit about how the prosecutor is chosen and how the judges are selected? I think
sure.
that's
so
very important.
Yeah, so there's an assembly of state parties, which are the state members of the court, and they meet every year. And they are, the judges and prosecutors selected via the assembly. Actually, the prosecutor, there's a new prosecutor election coming up. I don't know if that's going to be delayed at all because of coronavirus, but a new prosecutor should be taking over within a year. So we'll see how that goes. But again, it's very political. It's like the UN. You have a group of states and you have blocks of states. So, even if there are some states that are opposed to what's going on, you have coalitions of states that can maneuver. Of course, there's favors and political machinations going on over who gets appointed, who gets elected. And then just the other important part of the court is the victims unit. And that also is something unique to the court, that victims play a very large role in the court. And that also is quite problematic because, again, you're mixing even though you're trying to try someone for a crime, and not to say that the victims' views are not important, because of course they are, and they've suffered terribly, many of these people. But that should not sway whether or not there's jurisdiction in a case. You have to stick with what the law requires and not be swayed totally by emotion. And so I think there's some improper, so for instance, in the Israel case, which I think demonstrates the double standards, particularly against Israel, that's happened with the court, is a year ago, the pretrial chamber asked, I think it was the pretrial chamber, one of the judicial chambers asked for Palestinian victims to start approaching the court. And they had never done that before. So even before an investigation had even been opened, the court issued this call for Palestinian victims to come forward. They weren't even talking about Israeli victims. So I think even from that, it just showed already they were predisposed to be biased against Israel.
Richard, we'll get you to the almost last question and answer. And that is, as I said before, on the strategy. What are the tools that are available? One of the questions is, what about the financing of the ICC? And can that be used as a lever to put the framework back to what it was intended to be and get away from the strong political agenda? So I'd be interested in what the UK legislation aims at and what you think some of the other mechanisms might be.
I mean, the UK legislation actually does not target the ICC. It actually, what it does, it aims to protect British soldiers from prosecution after a certain period of time. So it allows for prosecution, investigation and prosecution of alleged war crimes for a period of time, and then it prevents historic investigations, which has been the main issue that we've been facing up to now. So it doesn't really go after specifically the ICC. As I said, I think that the key way of dealing with the ICC is by getting out of it. But of course, you know, that doesn't resolve the problems that the US and Israel faces, which are out of the ICC and still getting harassed by the ICC. And I think what I'm with Secretary Pompeo on this. You quoted him earlier, but you know, the ICC needs to be defunded, and I think 7 countries submitted made submissions to the ICC's pre-trial panel about the case on Israel, saying that they didn't agree with it. Seven member countries of the ICC did that, not including Britain, I should say, unfortunately. Now those 7 countries, they obviously feel strongly that this, and as we all know, this whole case is a complete, every aspect is a distortion, forcing some form of justice into a way in which it can deal with Israel. And those countries obviously recognize that. Now those countries should put their money where their mouth is, or even take their money out and not continue to fund the ICC. And that you know, also in terms of funding, countries like the United States of America, countries like the United Kingdom, other countries should sanction or should go after ICC money where it's coming through the international financial systems. It should seize it when appropriate. Because why should countries like the United States allow their senior soldiers, politicians, to be harassed by international criminal court officials who are clearly fighting a political war against them? There's nothing to do with justice. And then the other way, of course, is to do what, I mean, when Fatou Bensouda tried to go to America not long ago, she had a visa revoked. Well, let's revoke all the visas of all the people involved in ICC stuff from traveling to countries like the US, prevent them coming to the UK. These are the sort of actions that I'm certain that they will very soon review and reconsider the actions they're taking if it has a personal penalty on them. So I think, you know, every one of those actions, financial and diplomatic actions that can be taken to make their life as difficult as possible, all the while that they target countries which don't deserve and should not be targeted for their political campaign. And just very briefly, going back to the China question, I was kind of dodging it slightly, but I wrote, I'm not sure if I'm allowed to advertise myself on this, but I wrote an article which was today in the Gatestone Institute's website about China, which I go into a little bit more detail, but my concerns about what China's doing in particular in relation to the United States and the West. So your viewers might want to have a look at that as well.
Okay, I think that's a perfectly fair and acceptable self-advertisement. I will also add, by the way, that the NGO Monitor and allied Amicus Brief is available on the front page of the NGO Monitor website, so you're invited to go and read it and download it if it's useful to you. I want to end, and we are at the very end of this, so I want to end with, I'm not sure it's a question or a question that maybe doesn't need an answer. I want to quote Professor David Bernstein from George Mason University, who many years ago referred to the cult of international law. And I think in some ways it brings a lot of these threads together. The idea that international law is an empty box. You can put anything you want into it. And if it's a cult, you could put your main beliefs in there. It's like it becomes more of a religion, a sect, a means for ending warfare, of violent conflict. The idea that we can somehow use this concept of international law to break down what has been an inherent part of humanity from the beginning and change the world, and completely ignoring, and this I'm adding more to what David Bernstein said in my own element of this, which is that sovereignty, the ability of countries to decide, democratic societies to decide what's in their vital national interests, sending out soldiers, as Colonel Kemp, you've spent most of your life doing, risking their lives in order to defend the society, in order to distinguish between terrorists and their victims, their targets. And all of these things get mixed up in this cult of international law. It's almost a messy, or it is, I view it as a messianic cult, that everything can be changed. And the vehicle for doing this, the vehicles, I should say, because they are closely integrated, the Human Rights Council on the one hand, and the International Criminal Court on the other hand, working together to, and the people who are so adamant, who devote their lives to these cases, particularly targeting the United States, Britain, Israel, other democratic societies. I think you see all these pieces coming together under that framework of the cult of international law. And I'll just add one other aspect to that. In Israel, there are NGOs and individuals who very much favor and call for the investigation of Israelis for war crimes violations, just as you mentioned. I think it's called the Public Interest Lawyers Group in the UK, and there are other groups, CCR particularly in the United States, that within using the elements of democracy, the process of democracy, to call for this imposition of this undemocratic and unaccountable framework. Now that's all part of the democratic process. It's legitimate to push those agendas, but what happens is that adds to the tendency to pursue particularly the democratic societies and to give very little, almost lip service, to countries like Iran and China and Russia and other clear violators of basic international law norms and human rights. So I think, unless you want to add anything on that point, I will leave that as a discussion perhaps for the next webinar on this topic. And I'll thank both of you for joining in, and all the people who were participating, and also all the people who asked questions. I think this was, for me, it was very valuable to hear what everybody had to say. So thank you for joining us.
Thank you.
Thanks. Thanks.
And we'll invite everybody to come for the next NGO Monitor webinar, which will be announcing soon.